Please be seated.
Your Honor, good afternoon.
Good afternoon.
Allison Milkey of Young Conaway on behalf of the debtors. This is the time set aside for the debtors' sale of certain assets located in Florida. In particular, the debtors are seeking approval of the sale of real property located in Panama City Beach and St. Augustine, Florida, which is where the debtors' Golf World and Marineland facilities are located. In addition, the debtors are seeking approval of the transfer of 3 Dolphins from the Marineland facility to Theater of the Sea, which is an educational marine park also located in Florida. If it pleases the Court, I think we should start with a discussion about presentation. Last week, after all objection deadlines had passed and the debtors had resolved all the then pending objections, we asked permission for this hearing to go forward by Zoom to reduce the logistics and costs of having parties, including 5 witnesses from various out-of-state locations, attend in person. After we filed the agenda for the hearing, we received 7 letters, which were docketed on Friday afternoon, which I'm sure that Your Honor has seen, and another that was docketed this morning. There was insufficient time to have all parties make travel plans with less than a full business day's notice. We are prepared today to go forward via Zoom. The letters that were filed relate only to the Marineland sale, leaving the Golf World and the Theater of the Sea sales uncontested.
I think they relate to the Theater of the Sea sale as well, but okay.
As it relates to Marineland, we submit that while the objecting parties may wish to have their views known to the Court, such parties do not have standing to object to the sale. None of them are creditors. None of them are parties in interest in the case. None of them have an interest in the personal property. They have a generalized interest in animal welfare for sure. We, in addition, believe that there are no factual issues that are in dispute today. I don't think that anything that was said in the letters we disagree with. We have a sale in hand. There are developers that are the buyers for these locations, and we are anticipating transferring Dolphins. So I don't think there's any sort of contested factual issue.
I think the issues are surrounding the auction and who was permitted to be at the auction and how the auction took place and how it went forward. I think there are issues.
Your Honor, to that point, I don't think there's a contested factual issue with respect to the auction and the proceedings at the auction. There was no bid that was submitted by these parties. We have no APA. I don't think you will hear anything different from the parties that have submitted the objection. And the bid procedures expressly state, without discretion of the debtors, that those are not qualified bids. So I think that's a matter of interpreting the bid procedures order.
The debtor has no discretion with respect to how an auction proceeds. That's not the usual order. I'll look at this one.
Certainly, I think that under the terms of this, we could have allowed the bid if we had thought that it was qualified or that it needed some tweaking in order to become qualified, or if we thought it was in the best interest of the proceeding to allow the bid to go forward. Under the express terms of the bid procedures, and I can reference the specifics if you'd like, where the bid does not satisfy the conditions for a qualified bid, it is not a qualified bid, and those bidders are not permitted to attend the auction. It's on page 11 of the bidding procedures.
Well, I'm going to hear from certainly the parties who have indicated that they were prepared to work with the debtors. I want to understand about the timeline for this sale. I want to understand about what considerations the debtors put into determining when this particular auction should go forward. I will say that for future, what the papers that are put in front of me didn't provide me are any specifics about a particular property that was for sale. Each debtor's property is unique, as I understand it. There was nothing in front of me in these motions that told me, for example, that the property in St. Augustine is the Seaquarium, that it has, if I've got it right, that it has in it a scientific research aspect. Is it operating? Is it not operating? What is happening with all of the animals in that facility? Is there a group that's interested in trying to save it, as opposed to another facility that's closed down, is not operating, there are no animals? That's a pure real estate deal. Maybe this one isn't. So I got nothing of that. I knew nothing of that until I read the objections. So in the future, when you come to me with the sale of properties, I want to know about them. I want to understand what they are, the debtor's efforts with respect to them, so I can understand the picture of what is happening. But for purposes of today, we probably should go forward with the
Gulf World.
Yeah.
That's the Panama City Beach sale, Your Honor.
Yes, the Gulf World property, which does seem to be a pure real estate play, and which I think there are no objections to. The other thing that would be helpful is to not relate everything back to the bid procedures motion, okay? Because that's going to be every property then. I had to pull them apart. I had to figure out which objection went with which asset purchase agreement, and try to pull it together. So it would be helpful not to relate them back to just the generic bid procedures motion, but to relate a particular objection to a particular subsequent notice of filing of something so that it can be pulled together. But I think I've pulled it together correctly, and I believe that there are no objections to the Panama City, Florida Gulf World property. There are, I will hear them, but I don't think there are. I'd like to make sure I understand what that property is in connection with the sale, and I didn't see that in any of the declarations, and I just want to make sure I understand what this property is.
Understood, Your Honor. If what I've heard is consistent with your view, I think how we would proceed today is that we would put our declarations into evidence. In particular, I think we'll need that for the Gulf World sale, and I don't think there's any objection there. If there is someone that wishes for more information about Theater of the Sea or the Gulf World, we can address that.
It's me. I want the more information.
Okay. After we walk through it, I'm happy to do that, and then we'll see where we are. And if you think that we need some additional information or there needs to be someone in person or what have you, we can address that at the time.
Another for the future. I would like a separate declaration for each property. If there were 3, like here at the auction, I want a separate declaration on each one. Again, to be able to pull it together and know what relates to what. I view each of these properties as separate. These 3 were auctioned separately. I want one declaration for each one in the future. Okay?
All right. With that, Your Honor, before we moving into the summary of the sale process, which we are prepared to do, let's address the declarations and evidentiary record. So we have 5 declarants that are appearing via Zoom. The debtors have filed 5 corresponding declarations at docket numbers 632 through 635 and 638. Those are Mr. Carr's declaration at 632, and that is with respect to the Gulf World transaction at Panama City Beach. Hugh Jackson's declaration, which is at docket number 633, which is for the Theater of the Sea sale. Harold Boardwin, he is the debtor's real estate broker, and his declaration is at 634. Craig Cavalier, he is the successful bidder for the Marineland transaction, and that's at docket number 635. And the Wagstaff declaration, Mr. Wagstaff is the debtor's chief restructuring officer, and that's at docket number 638. We ask that the debtor's declarations be admitted at this time as direct testimony in support of the sales. And in addition, Your Honor, and I can pause if you'd rather, we would also ask that the affidavits of service found at docket numbers 466, 471, 495, 498, 527, 533, and 581 be admitted.
Okay. I'd prefer not to do it in this, again, sort of global fashion, treating everything as if it comes in with respect to every property, which it does not. Let me with respect to the Golf World property, that is Mr. Carr's declaration that is specific only to that property.
Docket number 632. It's specific to the Panama City Beach sale, which is the Golf World transaction that is uncontested.
Yes. Does anyone have any objection to Mr. Carr's declaration coming into evidence in support of the Golf World property? I hear no objection. That declaration is admitted. With respect to Mr. Fordwin's declaration, does anyone object to it coming into evidence for the purposes of the Golf World property? I hear no one. It is admitted for that property. Does anyone object to Mr. Wagstaff's declaration coming into evidence for purposes of the sale of the Golf World property? I hear no objection. It's admitted for that purpose. Those are the only three declarations, correct, for Golf World property? The other two go to other properties, correct?
That's correct, Your Honor.
Okay. So those three are admitted. Let me ask this question. Is there anyone that is objecting to the sale of the Golf World property? I hear no one. Okay. So let's proceed with that one. And I would like to understand and make sure I understand the nature of this property as well as the auction and the sale.
Okay. Your Honor, I know that you're a hard copy fan. I brought hard copies of the affidavits of service as well, if that's helpful for you. Would you like?
I forgot about the affidavits of service. No, I will admit those into evidence, certainly for purposes of this sale. Thank you for bringing the hard copies.
All right. So, Your Honor, to set the stage for the debtor's sales, I'll briefly summarize the sale process that led up to the proposed transactions, and then I'll summarize the material terms of the sale. I can go through each of the material terms for all of the sales, or just do Golf World?
No, just one Golf World.
Okay. Well, as the court well knows, the debtors began these cases in a precarious position. Having long been in default under their pre-petition loan agreements, the debtors were operating on fumes and required a substantial cash infusion to continue operating. The debtors initially focused on obtaining the necessary post-petition financing that was necessary to finance the cases, which also included caring for the animals. Ultimately, that DIP financing was approved in the amount of up to $43 million in new money loans. After engaging in a substantial amount of litigation, as this court was witness to on several occasions, over governance and other issues, the debtors stabilized their operations domestically and as best as possible in Mexico, and then commenced a sale and marketing process for all of their assets. Initially, the debtors focused on their domestic assets located in Florida. As Your Honor heard a little over a week ago, The debtors entered into an assignment transaction for the Miami Seaquarium, which is located in Miami, and had been working with various interested parties to obtain the necessary approvals and work on the operational transfer of that facility. Other than the Miami Seaquarium, the debtors have 3 Florida assets. Gulf World, and if you don't mind, Your Honor, I know that you don't want me to talk about the others, but when I'm maybe talking about sort of the marketing process generally, it all sort of overlaps. So I'll kind of reference, at least for you to frame it, what the operations are, where the assets are, that kind of thing. So there's 3 facilities other than the Miami Seaquarium. It's Gulf World in Panama City Beach, Marineland in St. Augustine, and the Dolphin Connection in Duck Key. The debtor's investment banker and real estate broker, Green Hill, which is the investment banker, and Keene Summit, the broker, respectively conducted the marketing of the Florida assets. Some of the assets were marketed as real estate-only transactions. For example, the Gulf World facility, because the debtors had ceased operations at that facility, had transferred Dolphins from that facility, and proceeded solely with a real property sale. The Marineland location was marketed jointly between Keene and Green Hill to buyers as either a going concern or real property transaction. And then finally, the Dolphin Connection facility is a leased location rather than an owned facility. And Green Hill led the marketing of that facility as a going concern.
Is that the one I approved? It's another one.
So, Your Honor, that one, which I'll get to in just a second, the debtors obtained some interest in that area, but determined to adjourn the auction as to that particular facility. Given that it is a going concern facility, there are some substantial licensing and regulatory issues and challenges with the transition. And so we've been working with various parties to see if we could get a bid that would be actionable at a value that makes sense. So the bid and objection deadlines for these assets, which we're calling the other Florida assets, was established as October 6th, 2025. The auction was scheduled for October 13th, 2025, and the deadline to object to the auction was established as October 16th, 2025. The bid procedures order, including the bid procedures, were served on the notice parties identified in the bid procedures order. That included the entire creditor matrix, which in my experience is actually a little unusual. So it went to the whole creditor body, contract counterparties, anyone expressing an interest in the assets, and various regulatory and governmental authorities, including the ones that were identified and attached to the back of the bid procedures order. For their part, Keene and Green Hill teams created and refined marketing materials for the assets, including a confidential information memorandum, which was provided to interested parties. The Keene team coordinated drone and exterior photography, which was used for marketing materials and property listings, and those were sent directly to strategic buyers and then provided to parties in interest. That was done both regionally and also nationally. The Keene team published print advertisements of the sales in various regional print publications, including the Miami Herald. And in addition, electronic marketing materials and various publications were circulated through digital advertisements, internet listings, industry publications, and various newsletters. Keene also coordinated a mass email publication to more than 20,000 individual parties from Keene's own proprietary database, as well as using some commercial real estate software. These efforts led to strong engagement. The debtors tracked the views of the electronic marketing materials and confirmed that we received tens of thousands of views for these assets. More than 180 parties executed a confidentiality agreement to access the virtual data room and to conduct due diligence. And both the Keene and the Green Hill teams engaged extensively with parties regarding various aspects of the assets and the proposed transactions. To establish baseline bids and in consultation with the consultation parties, which in this case are of the various lenders as well as the counsel for the Official Committee of Unsecured Creditors, the debtors selected stalking horse bids for both the Gulf World and the Marineland properties. We did that so that we could go into the auction with a floor price for the assets. After entering into the stalking horse bids, the debtors received bids in excess of those bids for each of the facilities. As mentioned, with respect to the Dolphin Connection facility, we received several bids at very low values for certain of the bids. For one of the bids, it was an interesting proposal that we believed was important to continue to discuss, so that has been adjourned. Your Honor, I'll put a pin briefly in sort of the process as it relates to Marineland. Leading up to the auction, we did receive some bids from one particular party, but it is all sort of wrapped up in the objection. So hearing Your Honor wanting to separate these, I'll pause and we'll come back to that. The debtors proceeded to auction. We did the auction together. We proceeded in two lots, and we started the auction with the auction for Marineland. Given that Your Honor would like me to segregate these, I'll move on to the Golf World segment of that auction. At that point, we had two bidders for Golf World. The starting bid was at $3.5 million, and after 5 rounds, By the Sea Resorts, which was the stalking horse bidder, was designated the successful bidder with a final cash bid of $4.55 million. Following the conclusion of the auction, the debtors filed notices of successful bidders, proposed sale orders, and executed asset purchase agreements, which can be located at docket numbers 582, 603, 629, 630, 631, and 647. The Gulf War property, Your Honor, just a brief bid summary. As I mentioned, it's a real property sale. There are no dolphins located on that facility. The successful bidder is By the Sea Resorts Incorporated, which again was the stalking horse bidder for the successful price, all-cash price of $4.55 million. The closing of the sales are contemplated to take place promptly, but with an outside date of not later than December 2nd. We anticipate closing as soon as possible. All of the sales are subject to a broker fee for Keene and Greenhill. In this instance, because specifically Gulf World is just a real property sale, the fee is for Keene at 3.5%. I'll speak just to the general sale objections that we received, putting aside the letters that were filed on Friday and Monday. The debtors received 3 timely responses. One was an informal comment from the Office of the United States Trustee, which we resolved with revised language to the proposed sale orders. We also received a cure and assignment reservation of rights from the landlord to the Dolphin Connection facility, which obviously is not going forward today, and an objection from Tradewinds, which is a judgment creditor of Controladora Dolphin, which is one of the debtors, and Tradewinds withdrew its objection per docket item 628. Here I'll just point out, with respect to the Boardwin declaration, Mr. Boardwin's testimony is that the debtors ran a fair and extensive and thorough sale process, that there was no collusion, that the auction was ran in a fair manner, that parties had the opportunity to have counsel present. None of the bidders are affiliates or are related to the debtors or any of their prior management. Mr. Wagstaff's declaration, the testimony there is that the debtors considered all of the bids and the circumstances. If the debtors determined in their reasonable business judgment that the sale was in the best interest of the debtors and their estates, and that the debtors have the requisite corporate authority to enter into and finalize the transactions. If Your Honor has no further questions, that is the presentation for Gulf World.
Okay, I would like to make sure I understand this facility. Is it closed?
It is.
Okay. You said there are no dolphins there. Are there any other animals there?
No, Your Honor.
Okay. So this is just a pure real estate deal?
Yes, Your Honor.
Okay. And I understand there are some co-tenants that have an interest in certain of the parcels that are also being sold, and that's all consensual as well.
That's right. Co-tenant is the word that we used. Your Honor, I think off the top of my head, I can't remember if it's 5 or 6, but there are a certain number of parcels that make up the Golf World facility or property. 2 of those parcels are 50% owned as tenants in common with this other entity called Flipper LLC, and Flipper LLC agreed to a purchase price to sell its portion of that parcel, which is in the APA, and so it is transferring its interest to the buyer in connection with the transaction.
Okay, and is Flipper LLC a related entity or not?
I don't believe so.
Okay. Are there any open issues with respect to representations that have been made or anything that need to be resolved before closing can happen?
No. As far as I'm aware, Your Honor, we're prepared to close as soon as all of the title documentation and deeds and everything are ready.
Okay. Would anyone else like to be heard with respect to the sale of the Golf World property? Yeah, I hear no one. Okay, I'm prepared to approve the sale of the Golf World property to By the Sea Resorts, who was a successful bidder. I'm also prepared to approve the Crotty Company LLC as the backup bidder with respect to this particular property. The declarations that have come in show that as to this property, it was marketed, an auction took place, there were rounds of bidding. The purchase price has increased from $3.5 million to $4.55 million. There's no suggestion of any type of collusion or other concern with respect to the auction. And the declaration of Mr. Carr supports the fact that I'm being asked to make that the buyer is a good faith purchaser, as that term is used for purposes of sales in the bankruptcy context. He specifically also testifies in his declaration that the debtor is not, buyer is not affiliated with the debtor in any way, shape, or fashion. I'm prepared to say that the price that has resulted from this auction is a fair price, given the market and given this facility. And there are no objections to this particular sale, which is a pure real estate sale of a closed facility. So I am prepared to enter that order. Let me see if I have any questions with respect to the actual order. I do. On page 4 of the order, paragraph C, there's a reference to 365.
I'm sorry, Your Honor, I thought we caught them all.
Okay, there are no, it's confirming, there are no contracts that are going with this. Okay. I think that's the only place I saw that and assumed it was discussed over. 4 on page 15. The question I have is, why are we incorporating my findings on the bid procedures order here?
Your Honor, I don't think it's necessary. You've made them once. Sorry. I don't know that we need them in this order as well.
Okay. Paragraph 5. Don't know that I'm approving the purchase agreement as much as I'm authorizing the debtor to enter into the purchase agreement, which I think is paragraph 6.
That's right, Your Honor.
Okay, and paragraph 15, this might have prompted the question. I remember reading this. Just again, there are no conditions precedent to closing that you're aware of that are unfulfilled.
I think these refer to purchase price has been obtained and the cash has actually been transferred, the title and deed have been finalized, those kinds of things. It is a fact that there are conditions to close such as that, but they are not, things that we would not expect to be met, at closing.
Okay. Paragraph 18. Is this relevant to this particular sale, or how is it relevant?
Well, Your Honor, I don't think that it is applicable. I also don't know that, I guess there's two parts. I don't know that there's any harm in keeping it, that it's qualified by the to maximum extent permitted under applicable law, A. But B, I think that the second part of that paragraph just references the discriminatory, the anti-discriminatory provisions of Section 525. But I don't know that I feel strongly about it, given that I don't think that there's really any applicability to this particular sale.
Okay. Well, before submitting your revised order, why don't you check with the buyer on that? And if it's relevant to something, I'll keep it in. I couldn't myself determine what it might be relevant to.
Understood.
Okay. Okay, paragraph 29. Purchase agreement may be modified. The last, it says, provided that any such modification does not have a material effect, does not conflict with the order, and prior written notice of such modification is provided by the debtors to the affected parties. Who would they be? We shouldn't be affecting third parties by modifying this agreement.
I'm not sure, but I think this is written to cover every exigency, not knowing what that modification might be. If you'd like, we can say, frankly, I don't know what the issue is that we would be solving for there. I think typically, Your Honor, requires some type of notice upon some material modification. Perhaps since this is limited to a modification with a material adverse effect, we could file an amended, APA or something on the docket if that was your preference.
Okay. Well, I also usually require something that says your modification cannot impact third parties, because it just can't after the fact. So that's why I'm not quite sure what this is getting to. If the parties want to amend something, I don't know what it would be here, that would not have a material adverse effect on the debtor's estate, conflict with this order, or impact third parties, I'm fine.
Okay, so are you suggesting that we revise the provision and prior written notice through parties and delete that piece?
I think, yes, I think it just can't impact third parties. If you're doing something that does something other than that, then you have to bring something in front of me, probably more than notice, probably also an opportunity for a hearing. I don't anticipate that here.
Perhaps we could say does not impact third parties without their consent.
Yes, you can say that.
Thank you.
Okay. Those are my comments to the form of order.
You're
so
welcome.
If you submit an order consistent with that, then I will sign it for the reasons that I have stated. And let's make sure, yes, that the order clearly identifies which property it is, which it does.
Thank you.
Okay.
So, Your Honor, help me help you on how to proceed. So I have an inkling that there won't be an objection to the testimony that we intend to submit with respect to Marineland. But I hear that Your Honor has additional questions, and I don't know if my summary of the sale process and reference to the declarations has helped to clarify that in any way. So I think I'd like to hear from you as to how you'd like to proceed in terms of the evidentiary record.
Well, we have objections that have been filed, some of which are by persons who really have no connection to the case.
Yes.
But two of which at least, and I didn't see the one this morning, so I don't know what it says. I guess I need to.
It says the same thing as the rest of them too, Your Honor. It says, please accept a $4 million bid, not a $7.1 million bid, because the animals. And I think it's one page. It's very consistent with the others, the substance of the others.
Okay. Well, what I want to hear, and I'll hear from the objectors, but by way of evidence, I think you have to put forward your case that this, which means I need to understand the facility, I need to understand what's happening, I need to understand what consideration was given to a group that would like to preserve the current state of what's there, of the necessity to go forward on this timeline with the sale. I need to understand that, because this is a unique facility, at least as I understand from the objections. And I didn't get any of that from what the debtors put in front of me. And this isn't just a real estate play. So it seemed almost cookie cutter, and this isn't cookie cutter.
I hear you. And what I'm hearing you say is you'd like us to come back at another time and supplement the record. One thing I want to make really clear, which may or may not sway Your Honor, but we don't have a qualified bid. We don't have any bid from anyone else, right? We have this bid, and it was obtained through an auction process after 34 rounds of bidding. And so I hear you. You'd like a better record, and we can come back and supplement that.
I think maybe there's many things that could happen here. And I'll hear from the objectors if they have any, I'd like to hear what they have to say. I don't know whether they can come up with more money or not. I don't know. This is not just highest and best, right? It's, I can look at what's best overall.
And we at least have some parties and a group that was able to get some financing in what looks like a short time frame. Now, if I had testimony that they've been working together for 6 months and there's no agreement put in front of you, that's different. But I don't have that. So I'm just trying to understand what the situation is here. This is, from what I understand, a unique property, and it should be viewed in a one-off situation. What are we doing with this property? How was this property marketed? Separate from, for example, the last property, because they're different.
Your Honor, I think that we have a sale hearing on Monday of next week. I know that the court is operating under interesting circumstances right now. I don't know how much time you have on Monday, and if we would have time for a full evidentiary presentation. And also, if you don't mind me taking just a pause and making sure, it looks like Mr. Breacher might have a question. Okay. Sorry, Your Honor. I think we just wanted to make clear that this is not a bid that only had a certain amount of time to be presented and is just now trying to cobble it together. I think that the debtors and the representatives have been working on something, with these individuals for a long time.
I have nothing on that. I have nothing in that record with respect to that.
We will come back.
And another thing I don't understand is at least as I read this asset purchase agreement, it's supposed to close in 30 days.
That's right.
Okay. And at least as I read the objections, you can tell me, there are 17 dolphins at this facility, and there are 1,200 other marine species at this facility. What's happening to them?
Your Honor, part of my presentation today was to talk about the asset purchase agreement, which is on the docket, and there is a built-in structure to allow for a post-close transition period of 90 days for transfer of the animals. And that process is well underway. So you will hear, and I think it's in Mr. Wagstaff's declaration, that the debtors believe that is patently reasonable and doable under the circumstances. And in fact, it's better for the estates for this to proceed apace because the debt maturity is the end of the year. We do have limited resources, and it's important that this asset, that the sale proceeding proceed and close on a reasonably efficient time frame.
Is this facility open?
It is.
Is it cash flow positive?
My understanding is that it's neutral at best.
It's not losing money.
Well, for now, that is the case, Your Honor, I believe.
Okay.
But this
No,
Chapter 11 cases, Your Honor, are a huge cash burn on the estates. And the longer that these operate and continue to operate, the longer the Chapter 11 cases have to proceed, and the more expensive it is. And it's extremely expensive, the run rate.
Okay. I have none of that. I have none of that in any evidentiary form.
I do think that Mr. Wagstaff's declaration does include reference to that, but I
read Mr. Wagstaff's declaration, and it certainly may have something in it, but it didn't leave that impression on me. Let's put it that way. It is... No, that's the wrong declaration. Maybe I didn't get the right one. In any event,
Your Honor, I think we need to come back in front of you and we can put on a full evidentiary record.
like to hear from Mr. Kazovitz, if you are on or you are represented by counsel.
I'm on, Judge.
Good afternoon. I did read the submissions that you have made and others have made with respect to what I guess I would characterize as a community coalition backed by a private family fund who's interested in keeping the facility open as both a research center and open to the community. I guess I'm trying to figure out how real this possibility is. What can you tell me about your efforts to date?
That's a good question, Judge, and thank you for allowing me to speak to you. We brought on the former manager of Marineland, and we've created a budget that shows that we can be successful as a business. The business model works. We were fortunate to have a contributor come forward and offer the $4 million plus, Judge, $1.5 million to get us through the next couple of months because this is the winter season and it's a very slow season. But we're convinced that we can make the model work, partly because Felicia Cook, who's the former manager, knows how it works. And in 2023, she showed a very good profit for Marineland. We believe we can do that also. What happened to us, and I don't want to belabor that, we were shut out. We were told by Riveron that we could bid by Michael Flynn. And then 2 days later, we're told you can't bid. Not only did Michael Flynn say we could bid, he said, don't worry about the APA stuff. We'll take care of all that when the sale takes place. And that's all in the documents that we supply to you, Judge. And as a last to this, we believe we're the only ones that can save this facility, this National Historic Monument, and save this and continue the dolphins' home. Some of these dolphins were born there. We have 3 generations in terms of some of these dolphins. And I'm just appealing to the court to give us a chance. We believe we can do it. I believe Felicia Cook's online with us also here today. She's the former manager. And we also have the Rubles online who are the people who are willing to help us save this. We're all really, Judge, not just about Marineland, because Marineland is not just the land, it's the dolphins. We're here to try to save those dolphins. I'm sorry if I belabored that, Judge.
Let me ask this question.
Yes, ma'am.
And you said the two the rubles are on the line.
Yes, ma'am.
Now, I'm actually not going to ask a question. What I'm going to do because what I really hear in these objections is that this coalition believes they were closed out of the auction, and so I think they'd really like me to reopen the auction. The question is whether I should do that. And I think the coalition needs to understand that the current high bid is in the $7 million range. And I think the debtor ought to consider whether to reopen the auction and work with this group to see if there's anything that can be done. And then I would hear the evidence about the highest and best. And I think in considering that, the timeline is something that the debtor should consider. And I make no decision at this time whether this timeline as it existed was appropriate or not. But from what I've read, this group should be given some consideration. And I'm not saying they weren't because I don't know the facts. And I don't know, quite frankly, what's already been shipped off site. The suggestion is there is stuff that's already been shipped off site. So while I hate this because I have everybody here, I hate to adjourn this hearing. I think that needs to happen. But I think in the meantime, while it's adjourned, there ought to be discussions.
Your Honor, I'll just say briefly, and I don't want to get into it because this is not an evidentiary hearing and we will have an opportunity to present it, but there are significant red flags with this proposal, not the least of which that Mr. Kazowitz's wife is a shareholder of Parent and has potential prior relationship with prior equity holders and former management, and all kinds of other things that we will certainly present to you at the appropriate time.
All should be considered, but I'm just saying there's the possibility that this auction will be reopened, so the debtor ought to decide how to come back to me and what it ought to do in the meantime. Because on this record, I'm not going to approve the sale. Maybe another record, but not on this record. Mr. Joyce.
Good afternoon, Your Honor. Mike Joyce for Apex Associates. Thank you for allowing me to be heard, Your Honor. Your Honor, Apex is an entity to be formed to hopefully bid on these assets and is affiliated, Your Honor, with certain of the pro se objectors appearing today. Your Honor, I rise just to say we would truly appreciate some additional time to participate in the auction. Apex would, Your Honor. And I also wanted to ask, Your Honor, if the court was inclined to require the debtors to renotice the sale objection in connection with any further auction proceedings.
Why do we need to renotice the sale objection?
Well, Your Honor, I don't want to dig back into the bid procedures and the sale, and the documents, Your Honor, but we had similar difficulty and in discerning deadlines, what assets were being sold, et cetera, et cetera. And that may be water under the bridge at this point, Your Honor, and admittedly, Apex was a little late to the game. But, Your Honor, to the extent there was any issues with the auction, we would want the opportunity to object to the sale.
Okay, well, I thought Apex is the Rubles entity, correct? Or is that a different entity?
It is affiliated with the Rubles, Your Honor.
Okay, and I have an objection. If there's some supplement to the objection that needs to be made, that's fine. But
Mr. Joyce, am I understanding now that you represent this? Who do you represent? Ask that question.
So I represent the entity, Your Honor, to be formed to hopefully bid on these assets. And this has come together in somewhat of an unusual way, admittedly, Your Honor. I think my clients on a pro se basis were attempting to bid on these assets. They had some difficulty doing that, as you've heard from Mr. Kazowitz today. And they reached out to me, Your Honor, albeit with limited time to kind of act. But that's the current situation.
Okay. Well, I think it is helpful that they now have counsel that you can speak with and coordinate with. And so, Mr. Joyce, I'm glad that you are representing Apex. When are we back here again?
Monday, Your Honor. If we're going to do a full evidentiary record, I don't know what your schedule looks like, but I think we'd probably inquire as to whether you have an earlier time in the day. And sorry, I'm particularly referencing live testimony.
I'll continue this until the 3rd at 2 o'clock. For an evidentiary hearing, but I would encourage the debtors to consider all their options between now and then, and that hearing could turn into a status conference if the debtors so desire. It could turn into some other request if the debtors so desire. But I will continue it to that time. Mr. Joyce, are you available?
I am available on the 3rd, Your Honor, yes.
Okay. And the parties should coordinate as to what that hearing would look like if it's an evidentiary hearing going forward. I'll see if I can make it earlier, but for the moment, that's where it's at.
Your Honor, there are a couple of other things on the agenda.
Yes.
I don't know if Your Honor has, sorry, I assume we're finished with the sale at this point.
This one, yes.
Okay. I think the only other matter that was still pending is going forward with the fee application. I don't know if Your Honor has had a chance to look at that. We were asked to keep it on the docket, or on the agenda, excuse me.
No, I was going to look at it yesterday, but then I found out these were contested. And so my time went towards that. So unfortunately, no, I did not have the time to look at that.
How would you like us to handle it going forward? Do you want us to take it off the agenda and you'll let us know?
It won't be, yes, it will not be going forward on the 3rd, but I will review the applications and let you know if I have any questions.
Okay. Very well. I think that's it for today.
Okay. Thank you very much.
Thank you.
We're adjourned.